Constitutional scholar and appellate attorney Adam White joins us now to talk about 303 Creative and the Postal Service case. He's senior fellow at the American Enterprise Institute and served on the Presidential Commission on the Supreme Court. Welcome back, Adam. It's great to see you. You're our regular analyst here. The Supreme Court term wrapped up with much commotion, but it seems free speech and religious liberty fared well. Let's discuss free speech first. The 303 Creative case. Lori Smith, the website designer who won her case out of Colorado, had this to say about her win. Let's take a listen.
My case is about speech, and when speech is concerned, speech should be protected. Today's victory protects not just me, but protects the LGBT website designer. Everyone should be free to create consistent with what he or she believes. And whether your views on marriage are similar to mine or perhaps different, nobody should be forced to create a message that goes against his or her convictions.
Now, Adam, do you think she was answering her critics who say this decision is discriminatory?
The Supreme Court did hold here that the First Amendment interests in free speech supersede Colorado's application of a non-discrimination law. But in this case, the justices in the majority made it clear, as important as anti-discrimination laws have historically been in many contexts, here the free speech interests in the First Amendment are preeminent. And so they weren't denigrating anti-discrimination laws across the board, not for businesses or for others. They were just saying that when your service that you're selling to the public involves creative speech, the First Amendment prevails.
Now, there are other criticisms as well. Professor Lawrence Tribe from Harvard Law School said the entire 303 Creative case was hypothetical. Here's his claim.
Lori Smith is putting a purely hypothetical case before the court. She didn't really have a business for customized web designs. She just asked hypothetically, if I were to design wedding sites on my website, would I have to do it for gay couples as well as straight couples? And the court, instead of doing what a normal court would do and say, that's a hypothetical question, we're not here to give advisory opinions. Instead of that, because this was a setup case that they were welcoming, they swung at it. And as far as I'm concerned, they hit a foul ball.
So what is he referring to about the facts of the case?
In this case, I think it's Professor Tribe who's swinging and missing. In First Amendment jurisprudence around the free speech, the free speech clause of the First Amendment, the Supreme Court has long protected the public from the chilling effects of restrictions on speech. Professor Tribe has written about this at length himself in the past. Here, Ms. Smith had the company 303 Creative. It was a creative design company. She wanted to expand it. She's very credible in her explanation of why and when and how she would expand it into creating wedding websites. And in this case, that's more than enough to justify her standing to sue against the Colorado regulations. I really think here it's Professor Tribe and other critics of Ms. Smith's speech. They're the ones, I think, who are creating arguments that don't really exist.
Now, Adam, you've been tracking how the Supreme Court has changed protections for people of faith. Some say that this win is part of the Supreme Court's chipping away at protections for the LGBTQ community that were granted by first the same-sex marriage decision in 2015 and then the transgender rights decision in 2020. Is this true?
No, not at all. And it's important to keep in mind that Justice Gorsuch, who wrote the opinion for the court in 303 Creative respecting free speech, is the same justice who wrote the majority opinion just a year or two ago in Bostock, the case involving the Civil Rights Act, sexual orientation, and gender identity. In the same way that Justice Kennedy before him, the justice who did more than any other justice to expand the court's recognition of same-sex marriage rights, was the justice who wrote the court's majority opinion in Masterpiece Cake Shop. Most justices, even the ones who have stood up for LGBT rights, they're able to recognize that free speech and religious liberty are also constitutionally protected values, and they're able to strike the right balance between them. This is not a case about rolling back any rights. It's simply a case where the court refused to further expand anti-discrimination laws to trump the First Amendment.
That's powerful. Well, let's discuss the big 9-0 win this term on employee religious freedom protections. DeJoy versus Groff, where a Christian postal worker won the right to rest on the Sabbath. How does this victory affect others?
At the time of year when we mostly focus on 5-4 and 6-3 decisions, it is good to see the court unanimous here. It's an important decision. The court was clearing up some bad case law that really did limit the scope of Title VII of the Civil Rights Act to protect religious liberty. The court unanimously reaffirmed that a company can't ignore somebody's religious practices unless the company itself really would face substantial hardship in its own business. The court clarified that in this case. It's an important decision. It's not a radical change in law, but cleaning up some bad precedent from the lower courts.
Well, we've seen that the Title VII discussion around accommodations for LGBTQ individuals also have made some Christians very worried. Does this Title VII clarification for religious accommodations do anything for the Christian employer or any of the other cases, the 303 Creative case?
Well, I'd say the Groff versus DeJoy case certainly does help to respect the rights under the Civil Rights Act of all religious believers, and including those who are facing hardship on other grounds. I'd say it's a pretty limited but important decision there. 303 Creative is also an important case respecting free speech, but again, it's not charting a broad new path. Rather, it's just protecting free speech rights that already exist.
With the Dobbs victory last year overturning Roe versus Wade and these decisions now, many are throwing their hands up in the air and calling for reforms to the Supreme Court once again. Representative Adam Schiff of California suggested packing the court. Are any of these suggestions you addressed before on the Supreme Court Commission up for real consideration?
No, not seriously. I've seen the court's critics once again calling for President Biden to pack the court. And President Biden, to his credit, has once again resisted those calls. We're going to continue to see these attacks on the court, calls to restructure the court, but it's impossible for me to see a path forward on that kind of structural reform now, thank goodness.
And what about the issues of ethics concerns? We're wrapping up the Supreme Court term. Everyone's taking a look at some of the claims of impropriety over disclaimers of the use of financial gain from donors, et cetera. What can you say about that?
Well, judicial ethics are incredibly important. Justices and judges in our country have immense power in their institution. And so we all should care about judicial ethics, including the justices themselves. I think it's important for them to take these criticisms seriously and to respond to them honestly. But at the same time, we can't allow judicial ethics laws to become a heckler's veto on the court's legitimacy. A number of people who are raising these concerns against the justices really are wielding them not in good faith, but as weapons. And we're seeing serious questions raised about the quality of journalism surrounding these attacks on the justices.
Well, that's definitely something that we're looking at. What else can we look at from the Supreme Court? Anything else that's on the horizon that we might see next term?
Well, the court's already announced that it will hear a couple of important cases in my usual field of focus, the administrative state, cases involving the Consumer Financial Protection Bureau and the powers of independent officers within agencies like the SEC. So those are very important cases. I'd say for this term that just concluded, we saw the resolution of the affirmative action cases. The year before that was Dobbs. Affirmative action and abortion were, of course, two of the central issues during the rise of the conservative legal movement. Now that those issues are resolved, at least for now, it'll be interesting to see what new issues appear on the court's radar.
Well, we'll be looking for that and asking you to come and join us to talk about it. Thank you so much, Adam.
Gladly.